Good afternoon, ladies, and welcome to this afternoon's webinar titled Creating Value Through Legal Compliance. My name is Hope Atuhaire-Kisitu, the Vice Chair of the ELS In-House Counsel Committee and your moderator for this webinar. I am delighted to also introduce my co-host, who has just been talking to Counsel for the Vision Group in. And if you don't mind, you could actually turn on your video so that the audience can put a name a face to your name. That's really at your discretion. Welcome. So that is our Annabelle, who will be our co-moderator this afternoon. Ladies and gentlemen, legal compliance has a number of facets, and this afternoon we will be reminding ourselves on some of the key aspects of that. And I say reminding ourselves because compliance is at the heart of what we do almost on a daily basis as in-house counsel. So it is my hope and that of everybody who's put this webinar together, that by the end of this webinar, we'll not only have refreshed our minds, but also learned some new perspectives that will drive improvements in our work on that front. I am therefore very delighted to be hosting our two speakers to discuss this topic. And I can see the numbers on the webinar keep going up. You're all very welcome, our participants, and we look forward to a very engaging afternoon. We will definitely have a Q&A session as we go along, but do make use of the chat room and also the Q&A to as we go along. Speaker this afternoon, that is Ms. Elizabeth Muro from Tanzania. Welcome, Elizabeth. Elizabeth is a young, dynamic legal professional with 8 years experience in Tanzania. And her experience is largely focused on the banking industry. She has worked in 2 multinational financial institutions limited and Bank of Africa, Tanzania Limited, all but similar, but they are related. She's responsible for secretarial management on pertinent legal issues, including corporate governance, labor laws, banking laws, tax and credit recovery, among others. And she's a member of the Tanganyika Law Society, East Africa Law Society, and holds an LLM in corporate governance and law. She's also an accredited director from the Institute of Directors, Tanzania. Elizabeth, very welcome to make your presentation. I now hand over to you. Thank you.
Thank you, Hope. Thank you, members. Just a few minutes as I try to share my screen. Thank you. I think we are all set. Hope, may I proceed?
Yes, you may.
Okay, thank you, Annabelle. And
yes,
good
please
afternoon. Good afternoon once again, members of the East African Law Society. Warm greetings from Dar es Salaam, Tanzania. I won't repeat much of what Ms. Hope had introduced me of as who I am and what I do and where I work and my experience. So I'll move on straight to the presentation.
You and I hope everybody can.
I think we can progress, Hope, yeah?
Yes, please.
Yes, thank you. So good afternoon again, once again, members of the East African Law Society. I won't go back again and refer to who I am. I'll just go quickly straight into the presentation for purposes of saving time. But before I go into the presentation, I'll just give a short brief of where I currently work, and having coming from the banking industry, and as we'll be seeing in the presentation later on today, we'll be relating much into the banking industry. So Bank of Africa Tanzania Limited commenced its operations in 1994. It currently has 19 branches in Tanzania. It is part of a Moroccan conglomerate referred to as Group Bank of Africa, with presence in over 18 African countries and a presence in Europe, Middle East, and Far East Asia. Our current status, we have a balance sheet size of 709 billion Tanzanian shillings, profit before tax of 3.2 billion, and a non-performing loan ratio of 4%, which is below the regulatory limit. So why is legal compliance, what is legal compliance, and why is it so important, and the reason why we're here all today? So put simply, legal compliance is an organization's adherence to set laws, regulations, guidelines, processes, and procedures. Legal compliance is crucial as it allows organizations to continue doing business in a particular jurisdiction. It involves not only knowing and understanding legislation that applies to organizations, but also being able to demonstrate that the business and its entities are compliant at all times. A robust compliance process includes, but is not limited to, keeping up with records of checks, having policies, procedures, processes in place around that particular legislation, and retaining evidence that the right people are taking responsibility for compliance. Failure to comply may lead to an organization being penalized by the regulatory authorities, facing monetary fines, reputational damage, criminal sentences, having their businesses suspended, or even completely shut down. So what is the role of an in-house counsel in ensuring legal compliance? The role is vast, as compliance is vast, and I will just mention a few of the roles that an in-house counsel plays. An in-house counsel can advise the board and management of an organization on legal compliance requirements, implications, and timeframe for compliance. Work closely with the risk assurance departments. These could be compliance, internal control, or internal audit, risk management of the organization to identify compliance gaps and best ways to address them. Engage continuously with regulatory authorities for broader understanding of the regulations and for effective implementation. Engagement with peers in the industry on compliance, common issues, challenges, and others. And continuous training of the organization's employees on legal compliance requirements, and constantly staying informed on various regulations and the changes that take place in the laws. But then again, we also look at what role does the board of directors of a company play in ensuring legal compliance. We note that the board, being an oversight function, playing the oversight role that they do, have a responsibility to approve policies geared towards achieving compliance, providing support to management in the engagement of external stakeholders such as regulatory authorities, holding members of senior management accountable for non-compliance, ensuring that the departments responsible for risk management, compliance, audit, properly positioned, staffed, resourced, and can carry out their responsibilities independently and effectively. And further, to use the work of these risk assurance roles, as mentioned above, as independent checks from information received by management on the operations of an organization. So what are the perspectives on an in-house counsel from the Tanzanian banking industry? Now, banks and financial institutions in Tanzania are regulated by the Bank of Tanzania. BOT is responsible for ensuring financial soundness of the industry by exercising its supervisory powers across the banks. There are two main laws that govern the industry, that is the Bank of Tanzania Act number 5 of 2006 and the Banking and Financial Institutions Act of 2006. Thereafter, the Banking and Financial Institutions Act 2006 has birthed a myriad of regulations that govern the daily activities of banks, including licensing regulations, capital adequacy regulations, credit concentration regulations, management of risk, asset regulations, and external auditors regulations, which we believe that the principles that do come out from these regulations can actually assist other industries as well. Some of the recent regulations and guidelines that have been enacted include the Banking and Financial Institutions Corporate Governance Regulations 2021, the Outsourcing Guidelines for Banks and Financial Institutions 2021, the Business Continuity Management Guidelines for Banks and Financial Institutions for 2021, and a recent circular on the modality to be held in terms of meetings via video conference. So the corporate governance regulations were enacted sometime in October 2021. The regulations are a response to a long-awaited cry in the industry for robust guidance on corporate governance practices in banks and financial institutions. Prior to 2021, the 2021 regulations, there existed Directors Guidelines of 2008. However, these guidelines were only providing a general conduct of the Board of Directors of banks and financial institutions. However, due to the fast changing and growing economic environment, the guidelines were not meeting the ever increasing demands of banks and financial institutions, hence the birth of these regulations, of which the objectives were to promote and maintain public confidence in banks and financial institutions, establish standards for corporate governance processes and structures, and provide guidance to directors for proper discharge of their fiduciary duties. I would like to mention to members that these corporate governance regulations are currently being used as best practice standards in other industries as well. And the principles that come from these regulations are worthy to note that they are known to improve governance, independence, and all that has been mentioned can actually be utilized by other industries and not just banks and financial institutions. So amongst the new features in these regulations include tenure, including imposing a tenure of 10 years for non-executive directors and chief executive officers, placing a responsibility of the board to promote a sound corporate culture, and provision on allowing banks to conduct board meetings held via video conference. And further, the regulator has enhanced the sanctions for non-compliance. So as mentioned previously, there were no regulations or guidelines in how long a non-executive director or a chief executive officer would be able to hold office. Now it is very clear they can hold office for 10 years. And if that particular director or chief executive officer or a managing director was part of a company which was a merger, acquisition, or takeover, then the said period of 10 years referred to shall include the pre and post combination of board members or chief executive officer. We also note that this particular regulations have stated that a person who has served as a board member of a bank or financial institution for a consecutive period of 10 years shall not qualify for reappointment in that organization until there's a gap of 3 years. We note that the regulations provide a moratorium for board members or chief executive officers who, by the time the regulations were enacted, had already served 10 years. So thereafter, they would be able to get a moratorium of 2 years, and that a person shall not be appointed as a board member or chief executive officer unless prior approval from the central bank has been obtained. Further, there has been restrictions for members of the National Assembly or House of Representatives or government or local government officials to join as directors of a bank or financial institution. The regulations have placed what we call more responsibilities to the board in terms of promoting a sound corporate culture. Once again, we note that these can also be utilized as a best practice in other industries in setting up policies, company policies, processes, and procedures. The regulation tells us that board of directors are now responsible for setting corporate values to be adhered by the board, senior management, and other employees, create a strong risk culture by conveying the board's expectations that it does not support excessive risk-taking, and ensure that all employees operate within the agreed risk appetites and risk limits. Further, to ensure that appropriate steps are taken to communicate through the bank or financial institution the corporate values, professional standards, or code of conduct, and ensure that senior management employees are aware of the appropriate sanctions that may be taken for breach of professional standards or code of conduct. We also see through the corporate governance regulations as part of the central bank trying to keep up with the times, but also, once again, is a practice that can be used around in any other industry, is the regulating of board meetings. The regulations tell us that video conferences can only be held once a year, and then the rest should be held via physical appearance. However, we do find that come February 2022, the Bank of Tanzania, having considered that we are still suffering from the COVID-19 pandemic, had provided a waiver up until the 31st of December 2022, where we find that we can still be using video conferencing as a mode of conducting board meetings. However, there are certain items, or rather responsibilities, that boards have to take note of, most especially board chairs and company secretaries, which is to safeguard the integrity of the board meeting by ensuring sufficient security and identification procedures, ensure the availability of proper video conferencing or other audiovisual equipment or facilities for providing transmission of the communications for effective participation of the directors and other authorized participants. Of course, to record the proceedings and to prepare minutes of the board meeting. Further, for safe storage and marking of the tape recording or any other electronic mechanism as part of the records of the bank or financial institution, at least before the time of the completion of an audit of that particular year. And further, to ensure that no other person that is concerned, that other than the concerned director or an authorized participant is attending or has access to the proceedings of the board meetings through video conferencing mode or other audiovisual means. And last but not least, to ensure participants attending the meeting through audiovisual means can hear and see the other participants clearly during the meeting. So in these regulations, our central bank were more specific in terms of non-compliance. In other regulations, they would only just mention that a penalty of the amount to be determined by the bank, for instance. However, this time around, they have included prohibition to not to declare dividends or paying dividends as such, suspension of issuing letters of credit and guarantees and other credit and accessing credit facilities at the bank, suspension of lending and investment operations, suspension of capital expenditure, suspension of privilege to accept new deposits, revocation of banking license, and suspension from suspension of office of the defaulting officer or a director or an employee, or total disqualification from a holding position of any bank or financial institution under the supervision of the bank. So from these sanctions, we note a wider extension of the net in regards to where the regulations stipulate that they may apply to directors, officers, or employees of the bank. And this was not featured in previous regulations. However, it further demonstrates regulators' strategic intent to ensure compliance in the entire industry without leaving any stone unturned. So how have banks, or most particularly a bank where I currently reside, ensured compliance of these regulations? We proceeded to conduct a gap analysis of the new regulations vis-a-vis old regulations, and communicated with the shareholders. The board, together with senior management, proceeded to do an amendment of the board charter, increase directors to meet the required threshold, and obviously currently recording board meeting proceedings in compliance with the recent circular being shared, and continue to monitor through risk assurance departments to ensure compliance, and creating further awareness to the board of directors on implications of non-compliance, and providing continuous updates on the status of compliance. So the legal compliance, therefore, is a broad subject. It varies from jurisdiction to jurisdiction, industry to industry, which is certain. What is certain, however, legal compliance remains to be the key reasons why businesses keep running. What we also know is that it's not a one-man job, rather a collection of team efforts from various persons in an organization. For an in-house counsel to add value and be considered the organization's voice of reason, alignment and continuous engagement with internal and external stakeholders is paramount. Shareholders and board of directors are being implored to appreciate implications of non-compliance. And this is shareholders and board of directors of any industry, regardless of the banking industry. We note that, or rather as gleaned from the corporate governance regulations, there could be heavy sanctions can be deployed, such as revocation of a banking license, or suspension of an office, suspension of office of a director or an officer or a member of senior management, which could matters that could be severely damaging to the reputation and outlook of the general public of an organization. So for safekeeps, let's comply. Thank you for listening. Asanteni kwa kusikiliza. Merci pour votre attention.
Thank you, Elizabeth, for your presentation. I'm just checking in. Can you hear me?
Let's hope we can hear you.
Thank you. Just to improve connectivity, I will not turn on my video. It's great that you can hear me. Thank you once again, Elizabeth, for your presentation. And just to highlight a few things that we can take away, although the focus was on the banking sector in Tanzania, I think what Elizabeth did highlight is we can actually borrow from this and apply in other sectors or other institutions what we can do best with compliance. I'm particularly drawn to the roles of the in-house counsel in ensuring legal compliance. And you talk about advising the board and management on the compliance requirements and working closely with other departments, for example, a compliance function, if it does exist, and the internal audit or risk departments, and also continuous engagements with the regulatory authorities, peers in the industry on issues and challenges, but also most importantly, training the organization's employees on legal compliance. And I think that is very key because we are not the only players when it comes to compliance. And of course, staying informed as to what is happening or new changes or new developments within your industry is also very key. The board also has a role to play, and Elizabeth did highlight that as well. Maybe before we go to our next presenter, we could actually see if there are any comments or questions in the Q&A or the chat room that we can take at this point, and then proceed to our next presenter. Annabelle, do you want to check if there are any questions under Q&A that we can respond to at this point in time?
Thank you, Hope. I've been looking through the chat section and really don't have any questions or comments there, but there is a question under the Q&A. It says, I'm going to read it verbatim. Thanks, presenter. Could you please comment on the closure of Bureau de Change in 2021 in Arusha and Dar, and the millions taken from owners without a word from Central Bank as to the fate of this money? I think, Elizabeth, that was meant for you.
Yes, Hope. Yes, that was meant for me. However, I don't think I'm in a position to advise because I believe this is a matter to be taken by the Central Bank themselves. Thank you.
I'm seeing some coming in under the chat section. Kevin is asking if outsourcing compliance issues, he's asking whether outsourcing compliance issues would promote East African integration.
I hope we have understood that question.
Let me rephrase it. He's asking whether Elizabeth thinks outsourcing compliance issues promotes East African integration.
Elizabeth, is the question clear to you?
I think the question is rather general. I would perhaps, if the member could be more specific.
Okay, Kevin Nguma, if you don't mind, you could provide some clarity on your question so that we are very spot on when we are responding to you. But we still have time at the end of the second presentation, and if we cannot do that right now, we'll still have time to respond to any questions that come up. But there's also a question from Ariampa Brighton, and says the quick one: how does non-compliance lead to criminal implications? I think you can respond to that, Elizabeth. How does non-compliance lead to criminal implications?
Okay, yes. So in our jurisdiction, at least in Tanzania, for instance, I believe there are some particular laws. I think it's the Anti-Money Laundering Act. It may not necessarily be the laws that I have been discussing here, but yes, it can lead, non-compliance of a particular action can lead to criminal sanctions. So it is possible.
If I get you correctly, you're saying that if the law has put in place a requirement for you to comply in a particular respect, and the organization or the concerned individuals are not complying as expected, there will be a sanction, a penal sanction to them. Again, it has to be imposed by law, right?
That's correct, Hope.
Okay, thank you. I hope that clarifies it for the person who was asking. Perhaps we could now move to our second presentation, and that is from our second speaker, whom I am going to introduce to you very, very shortly. Annabelle, are we good to go, or do we have more questions that we want to take on at this time?
We're good. We're good. We can continue.
Okay. Our next presenter is Mr. Al-Karim Hashim, who is a partner with Stallion Attorneys with over 10 strong years of experience in structuring investments and corporate entities in Tanzania and Zanzibar. He has been the lead legal advisor for both domestic and international clients on a number of projects, setups, mergers, and acquisitions, which involved high-level engagements with ministries and regulatory bodies in Tanzania mainland and Zanzibar. As a company secretary to various multinational organizations, Al-Karim is well-versed in developing corporate governance systems as well as advising on compliance matters. He has worked with and trained in-house counsel from a myriad of sectors, including financial institutions, hotels, telecommunication, and insurance companies. Welcome, Karibu Al-Karim, to make your presentation. Thank you.
Thank you so much, Hope. Good afternoon, everyone. I hope I am clearly audible.
Yes, we can hear you and we can see you.
Thank you. Thanks once again. Before I dived into what I wanted to share with everyone, I think it is maybe important to talk about why legal compliance is very important for any organization, whether you're a law firm, whether you are working as in-house counsel. Why is legal compliance important? I think Elizabeth ended with a very important statement. It ensures business continuity. And I will share some examples that many of you might be aware of. Everyone probably has heard of the company called Enron. American company. At some point, it was churning out revenue worth $100 billion. That's not small change. Huge company, and when it collapsed, I think the repercussions were felt, I can say, throughout the world. Yeah. But why did this come about? If we were to simplify that whole scenario, we can say that it came about because there were poor corporate governance structures in place. Executives were given too much power. There was no framework in place to keep a check on that power. They misreported earnings, and they pressurized their auditors to get rid of evidence. And in a nutshell, they misled the board of directors. Yeah, so that's a perfect example when we talk about why compliance is important for business continuity. But then we can also talk about a company called Toys R Us. For those who may have been aware of this company, it was a huge toy company, especially in Europe. They had branches all over the world. South Africa, I think at some point they had a branch in Tanzania as well. I remember they used to have a branch in Kenya. Not sure about the other parts. The reason they shut down is because they had a debt of £15 million pounds in unpaid taxes. So how does a company accumulate that much? Again, if we were to simplify it and go to the root, is because there were no good corporate governance systems. One of them being, risk committee. I think Elizabeth talked about the BOT being the body that regulates banks and therefore issues guidelines on corporate governance. Most recently in 2021, they sort of formalized all their guidelines. But before we dive into that, again, why is legal compliance important for organizations? Yeah. First of all, we're seeing more and more of a trend whereby if your company wants to be onboarded, whether as a supplier or as a customer, international companies, multinational companies, they request for KYC. And as part of the KYC, they will tell you, hey guy, do you have a work and health safety policy? Do you have a fraud reporting policy? Do you have a anti-bribery policy? So all of these things we will come and see, they fall under a legal compliance framework. Again, during tendering, it sets you apart when you can declare that we have these structures that protect our businesses and protect our customers and our service providers as well. They are also important when you are doing a due diligence, when you want to bring in investors into your business. Yeah, obviously in-house counsel would be involved in that process. During this due diligence, investors will want to know that, okay, I'm going to put in X amount of millions of dollars into your company. How sure am I that money is going to be protected or spent in the right way? These legal compliance mechanisms or corporate governance systems, they give them that comfort. Yeah. So I wanted to share that before I dive into what I have prepared for you. And what I have prepared for you is how to develop a legal compliance framework. So just a second, yeah. So any organization that wants to protect its continuity, wants to stand out, wants to protect its reputation, wants to ensure it is not being penalized by the government, it has to ensure that it maintains a high standard of corporate governance, yeah, which the benchmarks are compliance with the relevant laws, regulations, and government directions. Now, in the government directions part is where I believe in-house counsel really needs to play a role. Yeah, you need to be able to maintain relationships with the different regulatory bodies that your organization is subject to, because not all compliance issues will be issued through laws or regulations. Some are issued through directions, through the government regulatory bodies, or government statements being made or issued through various ministries. Yeah, so it's important for in-house counsel to really be abreast of the development in the legal framework. Yeah. The compliance framework outlines compliance measures undertaken within an organization, and it focuses on corporate governance and the following areas. First being regulatory and legal compliance. This forms the foundation of good governance and legal compliance in any organization. You have policies management process, contract management process, and monitoring and reporting. I have a few examples of compliance management policies. I'm sure and very confident that most of you must have come across these in your day-to-day activities, whether you're in-house counsel, whether you're private practitioners. Procurement policies, gift and benefit policies, fraud and corruption reporting frameworks. These are very important because almost all the East African member states have got anti-corruption laws in place. So to protect your own organization, it's important to have these policies in place. Work, health, and safety policy. It's now really picking up. A lot of international multinational bodies request if you have this policies in place. So these are just a few of the examples. Obviously, each organization would have its own sets of policies. Yeah, these are sort of guidelines on what you can do. Again, what the compliance measures look like, you need to have a legal and compliance register. Policies management, how do you manage all the policies that you've created? Contracts management, monitoring and reporting. When we talk about the legal and compliance register, again, depending on the country you're in, depending on the organization, you can each develop your own model, but the easiest one would be to have a section that talks about the particular law, and apart from the law, what does the law require? So that's your second segment. and then who is, what are the compliance issues from that particular law, who is responsible for managing or for overseeing compliance of that particular provision. So your register can look something like that, and you develop it from time to time, and we'll see that, yeah? So like I touched upon, you have the key legislative and regulatory obligations which are applicable to the organization. And Elizabeth shed some light, or shed a lot of light, on what is applicable in the financial sector, particularly in the banks. But so certain sectors have regulators that already have certain, a lot of compliance requirements, let's say insurance, telecom, but other sectors as well do have compliance issues. I talked about anti-bribery and you know, laws. Those apply to any sector you're in, you know. So what actions are taken to ensure compliance? Responsible officer, yeah. The register is normally managed by the in-house counsel and updated each annually by each department. Depends on the size of the organization that you have. Again, it needs to be approved by somebody at the very top. I've put that in brackets. That would depend if you have a CEO in your organization or who is the executive decision maker. Yeah, and it is maintained. I've mentioned a compliance unit. What comprises a compliance unit? Each organization is free to develop that. Yeah. Policies management, process to be followed when developing and approving of a policy. Who will be responsible for the development of the policy? Who cross-checks that it makes sense, it complies with the laws, and who approves it to be implemented within the organization. It's important to have a policy library, just a figure of speech. It doesn't have to be a physical library. It can be an online a database, intranet, you know, where you store all of these things, easily accessible to the right people within the organization. We're talking about senior management, we're talking about head of departments, we're talking about the people who are responsible to implement and enforce the policies. Yeah, we need to have a timeline. When will it be reviewed? The timelines and the review dates have to be recorded. Another very key, very key aspect is training and implementation of the policies. So what we have experienced as a law firm is that sometimes you have an organization that when they were setting up, they created these policies because they were required maybe by the regulator to create these policies. But the people within the organization don't know about the policies. They don't know how to implement the policies. So it's very important not to just develop them, but also to offer training on how they can be implemented. Not just implemented, we will come and we'll see when we talk about monitoring and evaluation, is how do you, when we're talking about implementing policies, how do we report an infringement of the policy? So that's very key for your wider team and wider organization to have. Who will manage the policy? Again, depends on the size, depends on sector. If a regulator requires a certain body to be set up to manage the policies, or again, it's up to the organization to decide. Contracts management, I think for lawyers, this is absolutely key. In-house lawyers, it's important to have an authorization metrics for signing contracts, MOUs, and other documents that bind the organization. Now, it's not all, obviously, contracts will be deposited in the contracts register or will be recorded in the contracts register. It's good to have a limit depending on the size of your organization. If your organization deals with, let's say, services between $10,000 to $50,000, then maybe that's the limit you want to put in. So you don't want to have the small contracts. Otherwise, your contracts register is going to be corrupted with a lot of entries which make it difficult to manage and use as well. It's important for in-house lawyers to review the high-risk contract clauses. Again, advise management that, hey, we've seen this contract, but we believe these terms expose us to certain issues. If I was to go back to Elizabeth's presentation again, she talked about the outsourcing guidelines issued by the Bank of Tanzania. One of the requirements in those guidelines, or one of the provisions, is that banks are now prohibited from getting services or key services from service providers on an exclusive basis. The logic that the Bank of Tanzania is using is that when there's a dispute, customer service should not be interrupted. The normal day-to-day running of the bank should not be interrupted, because at the end of the day, it is the customers who suffer. So it is important to know these things as in-house counsel, whether you're working in a bank or whether you're working in an organization that services businesses which are regulated, and such clauses are there, because you can't put that in your contract. So how do you go about it to protect your own organization? Yeah, what is the risk associated with that? Again, it is assumed that the in-house counsel would manage the contract management process in conjunction with the procurement office or the procurement officer. Depends on the organization. Each organization is free to decide. Now, I talked about having these policies in place is one thing, yeah, but how do we implement them, and why are they important? They can only be important, or the value of an organization will only see the value of having this framework in place and these systems in place if there is a robust monitoring and reporting ethic or practice within the organization. And this very much has to come from the very top. Again, Elizabeth talked about how the Bank of Tanzania has made it mandatory for the board to be responsible to ensure creating this ethos within an organization. And that can apply to any organization, whether you're Coca-Cola, whether you're Vodacom, whether you're Bajaj, it doesn't really matter. The top management has to take a very active role in ensuring that monitoring and reporting is taking place. I've used the senior internal auditor as an example, but it can be a compliance officer, and they need to report to senior management. And if you have an audit and risk committee, ideally they should be part of the monitoring process as well. So monitoring activities for key compliance matters supported by audit activities and reviews. At each audit and risk committee meeting, the ARC is provided with a report on the progress of the internal audit plan, progress of implementation of recommendations made by external audit and internal audit in prior audits. Super important. There is no point in having these exercises if we don't deal with the red flags or action items raised during previous audits, compliance audits. Yeah. Assisting senior management to undertake an annual risk register review in accordance with the organization's risk framework. The ARC will receive an annual report on this review. Again, to assist the senior management, annual review of the legal and compliance register, to collaborate with the Director of Finance in alerting senior management and the Audit and Risk Committee to any significant new or updated legislations which will impact the organization. So you can clearly see that over here, the in-house counsel will have to play a very key role. Again, to brief senior management on any non-compliance issues that have been identified, whether by the internal audit team or an external audit team, and what are the action items proposed to be taken. These ideally, if you're having quarterly board meetings, something needs to be mentioned during those board meetings, but should be definitely as a good practice, I would say, during every annual general meeting, there should be a segment of audit and risk that is discussed. Again, what is the ARC responsible for? The Audit and Risk Committee, determining whether management has appropriately considered legal and compliance risk as part of the risk assessment and management arrangements, reviewing the effectiveness of the system for monitoring compliance with key applicable laws and government directions. As with any good system, there has to be a provision for continual improvement. Staff reporting to management, the staff have to be given the confidence that they can do whistleblowing without repercussions, depending with the size of the organization. In-house counsel needs to be creative in how the reporting or whistleblowing can be done, whether a system, a confidential system is set up, or whether it is discussed during departments, depending on the level of non-compliance or breach. Yeah, but again, in-house counsel has to ensure that management is investigating the breach, and whatever the outcome is, it needs to be communicated to the rest of the organization, so the organization knows that these policies are not just there for the sake of being there, but they are being implemented. Yeah, and if there are challenges, they are going to be investigated and tangible action will be taken. Implementing an annual internal audit plan, regularly monitoring the implementation of recommendations, annual review of the legal compliance framework and compliance measures. So again, we're talking about reporting from a senior management level, significant non-compliance or increasing compliance risk. Yeah. Fraud and corruption monitor, overseeing the prevention and detection of fraud. Again, there's no need to talk too much about this because I believe all the East Africa partner states have anti-fraud and anti-corruption laws. So very quickly, that was me. Hope if I can hand it back to you.
Thank you, Al Karim, for your presentation. Very insightful, very informative, and I think very tickling in terms of what we do and how we do it. And I think we have been well guided on developing a framework for compliance. And I really like the link between compliance, risk, and corporate governance. And indeed, if there's non-compliance in itself, it is a risk. But also overarching all that is corporate governance. What structures and systems do we have in place to ensure that all the three aspects are working well for the good of the organization? So thank you once again. There are a few questions that have come in, I think, for which clarity might be needed. And I will go right ahead and read them out to you. One is compliance management an equal responsibility for all employees in an organization? Is compliance management an equal responsibility? In other words, do all the staff have equal responsibility for compliance in an organization? And are there degrees of compliance? In other words, can you comply to maybe 40%, 60%, or 100%? So are there degrees of compliance? And related to that is, when might a degree of compliance of less than 100% be acceptable? If we could start with those. Thank you.
If I may go first, whether compliance responsibility is do all employees have an equal responsibility for compliance? As lawyers, and as a lawyer, I'm skeptical to use the word equal, but I would say, and from the presentation, you can see that there is a party that is going to be responsible for creating the compliance system, but it can only work if it is a team effort. So one party needs to create it. There needs to be a party that is responsible for making sure the whole team knows how compliance works. So that is, for that particular party, I think they have a higher degree to ensure everyone else is well trained and knows how to do it. But the implementation of compliance, it is very much a team effort. We can talk about legal compliance, let's say renewal of a business license. Obviously, the party responsible for marketing might not be held on the same degree as in-house counsel, who I assume is responsible to ensure the business license is renewed on time. Filing your tax returns, these are all compliance issues. Yeah, so maybe the accounting department is to a higher extent more responsible. Yes, but there are other issues which throughout the whole team it is responsible. For example, gift policy. Everyone in the organization is subject to that. Anti-bribery. Everyone in the organization is responsible for that. But also the policies itself would state who is responsible for implementing, who is responsible for monitoring. But in terms of reporting, I think we cannot say it's a team effort. So I wouldn't use the word equal responsibility, but I would use it is definitely a team effort. I hope I have addressed that correctly. In terms of degrees, Liz, you will need to help me on this one. I will try and kick it off. Now, if your organization is subject to a regulatory body, then they have compliance scores that you need to meet. And if you don't meet them, they're going to be sanctioned. I think Liz talked about that. But for organizations that are not subject to specific regulatory bodies, then it is dependent on what your internal compliance system is all about. Is a 40% score permissible in a particular issue? Is it possible to reach 100% on all issues? Is that a realistic score for all the issues, or for certain things? Definitely 100% is quite achievable. For example, reporting, financial reporting, or tax filings. You know, it's easy to, yes, we have filed 100%, we filed it on time, so 100% score. Yeah, but in terms of degrees, what is acceptable, what is not, it depends on the sector that your particular organization is operating on. If there's a regulator that has set standards, otherwise it depends on nation is willing to accept, you know, as possible for a particular issue. Elizabeth, I don't know if there's anything you would like to add.
Yes, Al-Karim. So I would like to, I share your sentiment, but just to add, and also to borrow from some of the comments I'm seeing on the chat, that compliance is everyone's, is an organization, is everyone's responsibility. That's the general rule. However, when it comes to industry-specific matters, you will find that there are areas of compliance. For instance, you may not be able to achieve 100% compliance, but because of the engagements that you have done with that particular regulatory authority, you are being given a waiver or you're being given a moratorium, noting the efforts you have made for compliance. I'll give you an example of one requirement by the central bank for that applies to banks and financial institutions, but also to mobile network operators. And these are the balances of trust accounts that are to be held by mobile network operators. So the trust accounts held in banks by mobile network operators, it's not supposed to exceed 50% of that particular bank's core capital. And this has been a challenge, not only to many banks, obviously, because we're in the business of deposit taking, and that's amongst the ways we make our money. However, because the central bank has seen efforts made by various banks in terms of ensuring compliance, a moratorium of sorts and that has been issued in terms of ensuring that particular compliance. But obviously the rule is that to ensure that the deposits made by that particular mobile network operator are below 50% of that particular financial institution's core capital. And so this vary from one item to another. Things such as anti-money laundering, for instance, you can't get away with that. It's very clear. You have a clue that a particular customer is involved in money laundering activities, and you hide about that information. That's very clear that obviously you will be involved in that particular non-compliance, and thereafter the criminal sanction. So I would argue that matters vary from industry to industry, but in a particular matter on its own as well. But compliance is compliance, and it's everyone's business to comply in an organization. Thank you.
Thank you. Thank you to both of you, Elizabeth and Al-Karim, for your responses to those questions. Let me now hand over to Annabelle to pick up other questions in the chat room or the Q&A and have them responded to. Over to you, Annabelle.
Thank you, Hope. I will begin with a Q&A section. Actually, I have a question of my own, so I'll raise it first and then read maybe two others. On the topic of achieving 100% compliance, would I be right to say that I know it may not be possible in all circumstances to achieve 100% compliance, but if I was to make the argument that maybe if different organizations, depending on the sector, decided to maybe take on the combined assurance approach, in the sense that you work with the different, with the other assurance providers of the organization to align your assurance processes, wouldn't that also increase your percentage rating when it comes to compliance? Because if you work with internal audit and risk and any other assurance provider that you may have, internal or external, I feel like that could help bridge any loopholes that you as a compliance function may miss, because the compliance, at least I'll speak from my experience, that register can be big and there are so many laws out there. Sometimes you may miss something that maybe internal audit may catch or risk. So my question is, would I be right to rely on other or take on the combined assurance approach to be able to improve on my level of compliance? There's another question in the Q&A section, From Caroline, he says, I am a compliance practitioner based in Uganda with an experience in the compliance space from other jurisdictions. In developed environments, the legal and compliance functions are two roles that should not be combined because the mandates of the two functions are distinct. Nevertheless, for Elizabeth, if you have an in-house compliance function separate from legal, how do you share roles on regulatory compliance in your bank? I hope, should we answer those two first, or can I read two more? Because there are quite a number in the chat section.
I think let's have one more and then respond to 3 at a time.
Okay. I have one from Kelvin Nguma, who says, what are the challenges, especially for banks, to ensure they comply with outsourcing regulations in trying to access vendor services from regional or East African service providers? Does the regulation promote East African integration? I think he's trying to clarify on his earlier question. Is this more clear?
Yes, Annabelle, it is.
Okay. So we can begin with those 3.
Yeah, Elizabeth, you can have your take on those, and then Al-Karim can supplement thereafter.
Oh. Thank you, Hope, and thank you, Annabelle. So if you don't mind, I'll start off with the outsourcing regulations or outsourcing guidelines questions. So the outsourcing guidelines for 2021, in a nutshell, have provided for what is material outsourcing, what is not material outsourcing. And what it requires is that banks and financial institutions have to seek approval of these material outsourcing. So for instance, things like your things to assist you with the daily activities of the bank, such as your networks, mostly IT software, etc. And so you have to seek approval from the central bank for engaging these vendors and their payments thereof. And the whole purpose of this particular regulation or guideline is to ensure that services that are being rendered in Tanzania by Tanzanian banks are at arm's length. Now, back to the question, what are the challenges that banks face in terms of complying with these particular guidelines? A key challenge for me in my perspective is getting services that are affordable. I think we all know that IT services are not necessarily cheap. And in most banks, they tend to use services from a particular vendor that is perhaps providing services in other subsidiaries or in other jurisdictions where they have presence, and therefore enjoying an economies of scale. So I think that would be one of the biggest challenges, because companies in East Africa or in Tanzania in particular have been, research shows that have not been affordable when it comes to IT services in that regard. So I think that is one of the biggest challenge. And whether the regulations or the guidelines promote East African integration, I would say it actually does not, because if these services were actually more affordable, then the answer would be yes. If the services would be affordable in the East African region, then the answer would be yes. But currently, they are not as affordable as they should be, and therefore, we don't think that it promotes East African integration, in my humble view. Moving on to the next question in regards to the combined approach with the risk assurance departments in terms of achieving 100% compliance. I am of the view that you may not be able to achieve compliance by 100%, but noting that if internal audit, risk management, or internal control or compliance are aware of the similar issues, you tend to have a more combined approach or more united front, especially when it comes to presenting yourselves to regulators or presenting yourselves to the board of directors or any other external stakeholders that might be involved in trying to ensure that, in trying to see whether this, whether the organization is an approach that I currently use, or we currently use, and it has been working. There was another question on sharing roles of compliance. Currently, where I work, the compliance and legal services and compliance departments are completely different departments. But again, we work together. There are certain things that compliance does, we assist, and vice versa. So it's once again that combined approach in order to ensure that the organization is compliant. I don't know, Al-Karim, whether you want to add.
No, there's nothing to add on those queries.
Thank you, Elizabeth. There are a few more questions. Mostly, there are a lot of comments thanking you for your presentation. People find that webinar informative. There's also a question from Brenda. She says, hello, thank you for organizing this very informative webinar. What trainings or courses would you recommend to a lawyer who wants to specialize in legal compliance practice? I also have another question from Patricia. Well, it's a comment. She says, I share the sentiments of Carol. I work in a telecoms company in Kenya as legal compliance and risk in-house counsel. The scope is wide, especially since telecoms is one of the most regulated industries. So industries. So, I don't know if it was cut off. Oh dear, I think, Patricia, I'm going to request that you reshare your comment because I can't see the end of it on my end. So I'm going to skip to the next question. Yes?
That after 100%?
Pardon?
I think Patricia goes on to say, how does one ensure that the framework they develop is concise and high level without having too much information?
Oh, okay. Thank you. Should I get one more question or do you want to handle those two first?
Let's take one more and then Al-Karim gives his views and with supplements from Elizabeth.
Okay. Okay. Caleb is asking, how can one protect a whistleblower? So that's 3 questions. I think probably our last one for now. Al-Karim, over to you.
Thank you. I really appreciate our audience. I don't know if they have a WhatsApp group that they're coordinating these questions, because I feel the first set of questions are very bank related. And the second set is more towards what I talked about. So fantastic audience. Thank you so much. And thank you, Annabelle, for being an awesome moderator, Hope as well. So trainings, interesting question. As far as I know, we don't have a particular course in Tanzania. Now, I don't know in Uganda, but I'm skeptical. I'm skeptical because I would like to believe that compliance is a very, still relatively new concept within the region. First of all, people view compliance as an ethics thing or as a aesthetics, you know, so the company can look very nice and posh and things like that. But it's not. We talked about compliance being an important aspect of business continuity. You know, there's a lot of other advantages of that. Employment satisfaction, employee satisfaction, mitigating risks, blah, blah. In terms of training, my advice would be online courses. I know universities, especially in the US, they offer a lot of online courses in terms of legal compliance or legal and compliance, and how to good governance as well. That could be one way. Another way that I believe is more effective is one, forums like this, but two, also reaching out to practitioners or within your jurisdiction who you know already doing this, and seek for assistance. I'm very coincidentally that Liz is on this webinar. Her organization has reached out to us a couple of times on certain things that they wanted to be brushed, you know, given some training on, you know, so they would collect their team and we would give them that training. So that works, or even on a one-to-one basis. Personally, I reach out to when we're dealing with something that I feel I'm not comfortable enough with, or I need more guidance on, I do reach out to senior practitioners for their guidance. And it doesn't have to be lawyers. It can be anyone within an organization. LinkedIn is absolutely brilliant to connect you to people. And I found that people are more generous than we give them credit for. So if you do reach out to people on LinkedIn, I have tried this before, that, hey guy, you're working in this organization, I'm doing something that might be related to this. Do you mind having a cup of coffee? And people will share with you what they know. That is what I can say we are practicing over here, but I do believe it is applicable in any jurisdiction. Developing concise and high level, a system that is concise and has that is high level without having too much info. My first advice, and this is what we do when we're developing it, is you really need to understand it. There is no need to copy and paste the provision of the law, if I can use that as an example, or the provision of the regulation. So it is imperative to understand what exactly is required. If that is a challenge, then it is important also to seek out the regulator, that I'm trying to develop this for the insurance company that I work for, and we have written this down as an action item based on this regulation. Is this it? Is this sufficient, or is there information that we're missing out? So I think those two key things are very, very important. Apart from that, unfortunately, it is one of those tedious things. I'm sure if we were to talk to financial auditors, there's no better way to simplify the financials of a huge company. There are a lot of transactions, you have to put them down. So yes, it can be a very robust document, but I don't think it necessarily needs to be a very verbose document. Read it, extract the action items and put it down. It's when you're working in an organization that is regulated, there is no way. And that is why you would see organizations like banks and insurance companies and telecom companies, they have a big legal department and audit and risk committee and risk department, because they have a lot of compliance to work with. But with other organizations, you would see a legal department. If they have a legal department, it will be maybe 2 or 3 people. Mostly it's just one in-house counsel. Yeah, so it really depends on your organization, but I do believe in some instances you can't avoid having a very robust compliance document. Maybe Liz can share a different thought on that one. How do you protect whistleblowers? As I was presenting, I spoke that you need to be creative. An organization that has 5 employees, needs to have a very different set of or system compared to an organization that has 200 employees. With 200 employees, you may have a software. I know these big 4 audit firms. I remember I attended one by KPMG where they had a whistleblowing software that they give you, that people remain confidential, and it's not just internal employees but external people could do whistleblowing as well. So it depends on the size of your organization. Possibly set up a number or an email address that people can use. Suggestion box, maybe a bit archaic, but it all depends, I think, on the level or the type of the organization or the size of the organization. Liz, I don't know if there's anything you would like to add on.
Yes, Malcolm, just to substantiate what you had said. First and foremost, I would start off with the trainings. I also second what you had said about seeking advice from experts in the industry or senior counsels. But also when we're industry specific, then you find, for instance, central banks usually have a tendency of providing trainings, not only just trainings for legal compliance, but various aspects, risk management, internal audit, which can also benefit an in-house counsel or a practitioner, a private practitioner that is actually doing in-house counsel duties for a particular client. Our law societies as well for training. For instance, here in Tanzania, we have an Institute of Bankers, and so then there are various places of where you could actually get training, and training is endless. You can continue to train and train and train until you have actually become a trainer yourself. In terms of just to add on in terms of protection of the whistleblowers, I think it's very important for an organization to ensure anonymous reporting, and this can obviously be done through having a proper software for reporting on whistleblowing issues, and ensure that once again you train employees on the importance of being anonymous, and also assure them that that whatever they are sharing to the organization in regards to a particular item will remain confidential. So I think those are my 2 cents on those items. Thanks.
Thank you, Elizabeth. I see a number of people sharing other options for trainings that I'll read out loud. Judith says that the Kenya School of Law has a course on legal compliance audits and other kinds of audits. This can be useful for in-house practitioners. Caroline says compliance training. Compliance Institute of South Africa has the best and simplest model so far and have several practical short courses for starters. Judith says the Institute of Certified Secretaries in Kenya offers a course on governance, auditors, accreditation for very good grounding on corporate governance compliance. Yes, and then maybe to add to those, I know that the Chartered Governance Qualifying Program, then the one provided at the Chartered Governance Institute also has an aspect. There is a module for compliance, and also the International Compliance Association also offers a number of trainings on anti-money laundering, compliance, financial crime. So if you're interested in that kind of thing, those would also be options. I don't see any other questions. I do see a raised hand from Assumpta. Assumpta, if you have a question, kindly unmute and ask your question. Okay, well, the hand is not raised anymore. I'll take it that there is no question from her. Hope, I can hand over to you. We do not have any more questions.
Thank you, Annabelle. I just wanted to make a comment myself related to compliance. And we have heard that compliance is key for the long-term sustainability of an organization. And I just wanted to highlight that there is also an international standard for compliance management systems, and that is the ISO 19600. And this international standard provides guidance for establishing, developing, implementing, maintaining and improving an effective compliance management system within an organization. So if you have time, you could Google it or go to the ISO website and find out more about that international standard. In the chat, we have noted, members, your requests for the slides or presentations. And I want to say that ELS will follow that up. Some of you have also been asking whether this webinar was being recorded. Yes, it's being recorded, and it will be made available on the various ELS platforms as they usually do. But generally, we have received many comments thanking the presenters for the informative webinar and for the presentations, and hence the request for the slides. Time is still on our side. So I'm just going to ask both our presenters to give their final shots or parting shots on this presentation, because we don't have any more questions coming in. And I will ask Elizabeth to go first. Your parting shots on compliance, and thereafter we'll hear from Al-Karim. Over to you, Elizabeth.
Thank you very much, Hope, and thank you once again, members, for staying with us until this time. Thank you for the comments we've received on the chat box, the questions we have also received. My key takeaways from today, we have looked at legal compliance, the role of the in-house counsel. We've looked at the role of board of directors. We went on into the banking sector a little bit. And we also dived into how to develop compliance management policies. My colleague Al-Karim took you through that. And one thing is clear, that in order for this to work, it requires teamwork. It requires engagement with the regulatory authorities. It also requires that you have, in terms of ensuring that you have adequate staffing, because as we have seen from today's discussions, compliance is wide, it's a robust subject, it has a lot. So not only would it be important to have adequate staffing, but also working well with those risk assurance functions. So that would be it for me. And also to continuously keep learning and keep updating ourselves of the legal compliance requirements in order to achieve our goals as in organizations, or our goals as practitioners when we're representing these companies in the market. So that will be it for me. Thank you, Hope.
Thank you, Elizabeth. Over to you, Al-Karim.
Thank you, Thank you, Hope. Before I share my parting thoughts, I think it's imperative to respond to question by Moses, where he talks about the efforts of in-house counsel to lobby and cause shifts in the regulation so that the organization's optimal operation strategy is aligned with regulatory requirements. Absolutely, Moses. I would like to look at that as a suggestion or you know, a takeaway for other in-house practitioners and the legal fraternity in general, rather than a question, because it's true. As in-house counsel, you do have a role to play in the lobbying part. How effective that can be, I guess, is on a case-by-case basis. But yes, whether it is through writing a white paper or through the law society or directly through the regulator, I do believe there is room to raise concerns. If I remember or recall Elizabeth's presentation, she did talk about the fact that due to the COVID pandemic, certain compliance issues were moved forward. And this is simply because the individual players or, you know, the in-house counsels, definitely they play a role in addressing the regulators. Yeah, so yes, in-house counsel does have a role to play on that, which brings me to you know, my parting remarks. I do believe as in-house counsel, we need to appreciate just how important legal compliance is. It's not just to tick off a box, but I shared with you some. Enron was a huge company. Almost everyone's heard about it. And when it failed, it caused a global crisis. Yeah, so let's take those lessons and bring them to our organization. Elizabeth talked about staffing. I think training is also very important, and this is where in-house counsel needs to play a very active role in developing training skills and developing trainings and executing the training, but also being able to advise senior management on the importance of compliance, having reporting systems in place, and ensuring that those reporting systems and the complaints or whatever it is are being acted upon, the red flags from the audit. It is important, first of all, as in-house counsels, for us ourselves to be educated in these compliance issues so that we can advise our organizations much better and, you know, have value in the advice that we give them. Apart from that, I'd just like to say thank you for all those who attended, took your time to attend this webinar, those who raised questions, but very special thank you to all those who are sharing information to the rest of us to learn new things and where to access this information. It is fantastic. Thank you to the society for organizing and the moderators. Asanteni sana.
Thank you, Karim, for your parting shots. And I now want to request Annabelle to give a vote of thanks to our presenters and the audience who have stayed with us up until this time, for their participation, for their comments, and it's been very interactive. Thank you to all of you for your participation. So Annabelle, please go right ahead and give a vote of thanks to everybody here.
Thank you, Hope. I'd like to thank our panelists for today for accepting our invite, being gracious enough to even prepare such insightful presentations and helping us understand the importance of legal compliance. We do not take it for granted. They're very busy people, and we are really grateful that you are able to take off these hours in your day during a busy week to partake in this webinar. I also like to thank our attendants for the day. We're really grateful that you joined in large numbers. I think at some point we're about 250 on the call. we're really grateful that you all took off time during your busy schedules to attend, and we hope that this was, well, from the comments, people really enjoyed, but I'm grateful, and I hope that everyone picked a thing or two today. I'd also like to thank Hope for being gracious enough to take us through this session. She moderated well. At least I know I enjoyed, and I was able to stay on the call because she was engaging. So thank you, Hope. I would also like to thank the Secretariat for making this webinar possible, giving us the time, the Zoom link, and helping us prepare. We do not take that for granted. And then finally, maybe the ELS in-house committee for coming up with such an insightful topic to discuss today. Thank you all. Hope, over to you.
Thank you, Annabelle, too, for co-moderating this webinar. And I would like to encourage all the people who have attended, if you have any comments on what you would like us to focus on in our upcoming webinars, please do make your comments in the chat. We will take that up and ensure that we bring to you exactly what you want to hear. So at this point in time, I think we've come to the end of our webinar. We have really worked well within the time. We are 15 minutes before 4 o'clock. And so that's still good time. Thank you once again to all of you, and goodbye from us. Thank you.